Good afternoon, students. Tell the others to join as quick as possible. All right, because I think you people got a long break by Dalbir sir. So tell them to join as quick as possible. Okay? All right, so good afternoon, students. Can we start now? Because I think we have waited a long and I think we should start now. Am I audible? First of all, confirm this. Thank you, Ishika. I think some students are still in the hangover of festival. All right, so good afternoon, all the students. And now I think we are good to go with. So last day we completed all 22 questions of the prospectus chapter. And the last question what we dealt with was what is liabilities for material misstatements in the prospectus. And we learned that there are two kinds of liabilities. The first one is civil liability and the second one is criminal liability. All right. First one is the civil liability, second is criminal liability. Now, next question to this is very much interesting. What it says, question number 23. Now you see, this question is actually the loop. The next question is the loophole in the law. Have you ever heard that law itself says that if you want to set up, if there is a misstatement, directors had signed the prospectus, promoters had signed the prospectus, experts signed the prospectus. So obviously they all would be found guilty under the charge of fraud, section 447. But how can we save him? Suppose we are the lawyers and the advocates. How we can save these three people from the punishment? How we can save them? That's what we are going to learn. So write down, guys. Defense available against civil liability and criminal liability. That is how they can prove themselves non-guilty if these charges are dropped. Write down the question here. What are the defenses available to directors, promoters, or experts against civil and criminal liability? What are the defenses available to directors, promoters, and experts against civil and criminal liability? I hope you completed this. So let's learn about what are the defenses available. So the question goes in this way: suppose there is a director. Director's name is Mr. Milan, and Mr. Milan is working as a director in, let's say, Meenakshi Limited. And suddenly this company goes for the public invitation for debenture of rupees 50 crore. My question is, if you are issuing the debenture publicly, is it compulsory to issue the prospectus? Is it compulsory to issue the prospectus? Answer will be absolutely yes, because the term security is written there, right? So security includes shares as well as debenture. So it goes for public invitation of 50 crore rupees debentures. But suddenly Mr. Milan realizes that certain information in prospectus is wrongful. Certain information what is provided in the prospectus is totally wrongful. Okay. He wants to save himself from the liability of section 447. Explain what are the remedies available to him. What are the remedies available to him? So this is the question. So Mr. Milan, he suddenly came to know about that, okay, prospectus is drafted by using certain wrongful information, and which makes prospectus containing material misstatement, and he wants to save himself from the liability. He wants to save himself from the liability. So how you people will go about it? How you people will go about it? That is the question. अब आप कैसे जाओगे? How you will go about it? So here there are certain differences. You see, entire prospectus issue has these three kinds of steps. Three kinds of steps. Step number one, before sending to authority, that is ROC and SEBI. Before sending to ROC and SEBI, that is the first phase of prospectus. Second is, it is sent to ROC and SEBI, but not issued to public yet. And third option is issued to public. There are three different phases. First of all, prospectus is prepared. but still you have not given this to ROC and SEBI. I think all of you in this classroom knows very well that every prospectus what you prepare needs to be registered with ROC and SEBI. Do you know this? Hello? It needs to be registered with ROC and SEBI. I think everyone knows about this, right? All right. So the first is, if you are at the first stage, what are the options available? If you are in the second stage, what are the options available? And if you are at the third stage, what are the options available? So here law says, if you are at this stage, that prospectus is prepared, but still it is not sent to ROC and SEBI, then such director, such promoter, or such expert has to write the withdrawal of consent letter to company. In that letter, it has to write that, okay, fine, earlier I gave my consent, I signed to this prospectus, but now I want to withdraw this. Now my consent, I want to take it back, because earlier I was thinking that whatever is written here, that is perfectly fine. But now I have certain evidences which prove that this prospectus is malafidely drafted, and that's why I want to take my consent back. So guys, if you have withdrawn your consent by writing a letter to the company, and later on, even if your name is appearing in the prospectus, are you guilty? Will you be punished under section 447? Will you be punished under section 447 after withdrawal consent? Come on. Answer will be no, not at all. The simple reason is, now you people have this evidence with you which clearly states that you had given the consent, but now you have taken it back. You had given the consent, but now you have taken it back. Now second stage is little bit more advanced, because now it is sent to ROC. So again, what rights you have, you can withdraw the consent by writing to the company as well as by writing to the authority. So you need to write the letter to company as well as to authority and tell them that yes, earlier I gave my consent, but now I want to take it back. Are you getting me? ROC should also know that you have taken the consent back, and then and only then it will not consider you in that particular matter issuing prospectus. Third problem is, what if you have already issued to public? If it is already issued to public, then understand mere writing the letter to the company is not sufficient. So along with writing the withdrawal consent letter to the company as well as to authority, you have to also advertise in the newspaper before it reaches to public. Before it reaches to public means what? What if all the people have read it and already invested? Then nothing can happen. So before, sir, your voice is breaking. Is it so? Am I audible properly? Am I audible properly? Please confirm. Or it is breaking. All right, Mahima, I request you please check your internet connection. Fine. So what I'm trying to say, before the people starts taking decision about investment in the company, you should communicate them, and you should stop them from, like, you should communicate them by advertising in the newspaper stating that I want to withdraw my consent and do not consider me for your investment decision. And if you are doing like this, I won't be held liable in the future. I won't be held liable. Are you getting my point? So if these three stages you are covering, then these three can be set up as the very good defense. And then even if your name is appearing in the prospectus, you can save yourself from the upcoming liability of section 447. Fourth defense is very important. The fourth number defense. Fourth number defense. Students, what if you prove that the statement what you signed, obviously it is misstatement. Fourth difference is very important. It says that prove that misstatement is not material in nature. If you prove it that misstatement is not material, material means over here significant. I think all of you know, right? What do you mean by material here? Material means which can affect the decision of the reader. If you prove that obviously it is a misstatement, it is the wrongful thing, but it is not that much significant so that it can influence the decision of the investor. So if you prove that this misstatement what you provided in prospectus, if it is not material in nature, then obviously you are not found guilty. Fifth defense is my favorite because fifth decision favors the natural justice. Natural justice. Before I teach the fifth point, you tell me one thing, guys. Is it possible that one human can manipulate the brain of others? You understand a lot of terrorists who are suicide bombers. Have you heard about suicide bombers? Hello? Suicide bombers who are ready to sacrifice their lives. So understand how they are made up to that level that they are ready to sacrifice their life. That is just because of the words. They are motivated in such a way by showing a lot of videos, by giving a lot of hatred speeches. All right, they are full with a lot of hatreds that at the end of the day, they are ready to sacrifice their lives. They are ready to sacrifice their lives. They are ready to sacrifice their lives. So what I'm trying to say, manipulation and brainwashing like technique is possible in the human mind. So as being expert, as being promoter or as being director, if you prove that during giving opinion during giving opinion at the time of signing, circumstances were set in such a way were set in such a way so that anyone could believe statements as true. The circumstances are so manipulated that anyone could believe that the statements are true and not a misstatement. And later on you discovered, hey guys, is it easy to manipulate the evidences? And the same thing is happening in the court as well. People are manipulating the evidences and they are presenting it, right? So suppose I am a chartered accountant, but all the documents and the information what you provided me, if that was manipulated, I do not have any mechanism to get to know whether the information what you are giving, that is true or not. That is true or not. तो वो मेरे लिए मैं नहीं जान सकता. So on that information basis, if I have given my opinion, then I'm not guilty. But I have to prove it. That information provided to me and the circumstances what was said at the time of giving the opinion, that everyone could believe that this is not misstatement, but it is the wrong. It is the rightful thing. It is the true thing. So these 5 different defenses are available if you want to escape yourself from the liabilities of civil and criminal. But you know what? Personally, I don't entertain these kinds of things as being the part of the law. Why? Look, don't you think that these are the loopholes given by the law itself to the people that if you found guilty in the eyes of law, you can use either of this mechanism and you can set free yourself. So actually indirectly the law itself is teaching to the people, isn't it? So these all are the ways where you can just found yourself non-guilty. Okay. All right. So please take down these notes and now write down these notes as well. Complete this part first, and then I'm going to give you the another notes. Please show the question once again. Just a second. Oh, where is my? Oh yes, this one. It is completed. हाँ ठीक है भाई चलो after then all right, so these all are the different defenses available for civil liability, and I want all of you to just go by this one by one. Cream stuck is it? Now it's fine, all right. And make it 5 stars, guys. All this part are the part of your exam. Okay. Copy this part as well. All right, so let's go to the next point now. After then, we have certain miscellaneous point. Now what I'm going to do is I'm just presenting you the entire material of prospectus, what is here, and whatever topics I have not discussed in the class, we're going to go with that. Okay, so if anything is left, let's go with this. So meaning and definition of the prospectus is done. We understood that what do you mean by the public offer. This topic is also completed. All these cases we have completed. Contents are as per the section 26. It is the homework. Then section 27 also we have done, right? According to section 27, what we have done over there, changes in the objectives of the prospectus. Do you remember special resolution plus newspaper, exit option, all that stuff? We have already done that. Section 28, offer for sale by the certain number of members. Then when it is not needed, after then when RFC can refuse. I think all these questions we have done. Section 25 is about the deemed prospectus. Under what circumstances it can be considered as deemed. Shelf prospectus, red herring prospectus. I think everything we have completed. Fine. After then we have this civil liability. Defenses also completed. Criminal liability, it is also completed. Defenses, then this is, I think you do not know, liability under section 36. So punishment for fraudulently inducing persons to invest money. So if you are making a fraud with anyone and inducing them to invest in your company by providing the wrong information, by going with the wrong presentation, then section 447 will apply. And what is section 447? I think we have done in detail, isn't it? It is AK47, having maximum imprisonment of 10 years if the fraud is more than 10 lakhs. But if it is less than 10 lakhs, then if it is less than 10 lakhs, then it would be 5 years. Now here, this point, students are a little bit confused about, so everything is fine, but what do you mean by the section 37? That we could not understand. Section 37. If you look at this, again, it is for the first time introduced in the Companies Act 2013, which talks about here the class action or action by affected persons. Now, what do you mean by this class action or action by affected persons? So for that, let me tell you one case study. All of you know about the case of Maggie. In the laboratory test, it was detected that Maggie company, those samples, while testing the Maggie samples, it was detected that it contains the excessive lead. Lead, you know, right? It's called lead as well. Excessive lead, which is very harmful to the human body. And case was filed. Now, when it was detected that the samples of Maggie contains such harmful ingredients in noodles, what do you think? Only one case was filed? No, one case was filed from Haryana, one was filed from Gujarat, other one was from Maharashtra, one was from, let's say here, Tamil Nadu. So from different states, there were many complaints had been filed in police station against company Maggie. Suppose there are somewhere around 15 complaints. 15 complaints. Now the point is, all these 15 complaints are registered in the different states. That means different investigation. Look at this, different police station. Second thing, different investigations, different courts. different judges, different lawyers, different arguments, and there may be possibility of having different judgments. Do you believe in this? Because all these 15 complaints had been filed in the different states. Isn't it a waste of resources from the government treasury? Waste of resources, because 15 judges are occupied only in one matter, only in one single matter. Isn't it a waste of time? What do you think about it? Huh, students? Isn't it a waste of time? So, when this matter is observed by the High Court or the Supreme Court, what generally they do is there is no any point to waste this much resources for the same matter. So, let's club the matter. Club in the sense, let's merge the matter. And instead of judging this differently, only one case will be filed as a class file. Class file in this is as a group of case, and it will be heard either in Delhi court or in the Hyderabad court or in Karnataka court or in Gujarat court. Any one court will be decided by the Supreme Court. So all the 15 complaints will be merged together and it will be heard only at one court, so that we can save the time, we can save the resources for the same matter. So whenever the company makes the fraud, you tell me, does it affect only one person or many persons? Whenever a company makes the fraud, whether it is Satyam Computers, whether it is fraud made by Kingfisher, or it is made by anyone. So whenever there's a fraud, the question is, will it affect one person or many people? So it is going to be affected to a lot of people. So whenever there's a share market fraud or prospectus fraud, a lot of people will file the complaint from the different corner of the country. So instead of taking them as an individual complaint, law allows them to go for section 37. Section 37 says that they need to create a group. They need to create a group. That group is known as a class. And the whole group will file only one complaint. Only one complaint for the fraud, where the welfare of all the victims will be taken care of. Will be taken care of. So that is the section 37. Okay. So if you read section 37, look what is written over here. A suit may be filed or any other action will be taken for section 34, that is for the civil, 35 for the criminal liability, 36 for the fraud by any person or group of person or any association. So now the judgment will not be delivered on the basis of just one complaint. Even the group can file common complaint. Even the association can go for the common complaint. So section 37 not only provides for individual action, but also for the class action. So now all of you clear with the section 37? Come on. So one entire group can also file the complaint instead of one individual. That is known as class action. That is known as the group action. Section 37 here. All right. All right. Golden rule for framing of the prospectus. I want to give you it as a homework. There is nothing much in that. The last point we are going to discuss here, and that is the section 38, which talks about allotment of shares in the fictitious names. Allotment of shares in fictitious names. Section 38. Section 38. Now look, when I talk about this question, section 38, why anyone will go for fictitious name? Why anyone will go with the fictitious name? So sometimes it is beneficial for both the people. Both the people in the sense, it is beneficial to company as well as it is beneficial to shareholders. How? Okay. Do you know what? If company is very popular, for example, company like State Bank of India, you know that State Bank of India, LIC like corporations are always backed by the government. And you tell me, the government itself is in the support of such corporations. So what about the future? Future is bright or future is dull? What do you think about it? The future of such corporations is what? Obviously, the future is what? Very much bright. काफी अच्छा future होने वाला है इन लोगों का. And that is why when these companies are coming for public issue, when these companies are going for public issue, it is a very good opportunity for investment. A very good opportunity for investment. But let's say even if they are going for the 50,000 crores, even if they are going for the 50,000 crore rupees share capital, it would be oversubscribed. It will be oversubscribed. It will be oversubscribed. Got it? Just a second, please. So understand that if you apply for, let's say, 5 lakhs rupees shares, probability of allotment is more or less for such companies. Because sometimes even if company wants to go for 50,000 crore rupees share capital, people are so crazy for the investment that sometimes the shares IPO goes for oversubscription. Have you ever heard about the oversubscription? Hmm? Sometimes it is possible. So all the applicants who are applying for the shares, the possibility and the probability to get the shares are less. And in order to increase the probability, what is the best solution? Instead of one, you try to apply many names. Possible or not? For example, in my family, there are 5 members. I will apply in all the 5 names. And if I have less names, then I will try to use the fictitious name. Fictitious name. Because the more number of members I will apply for, there are more chances that I will get the allotment of shares. I will get the allotment of shares. Now, this is the benefit from the shareholders point. But another question here is, what is the benefit from the company side? Company side. Okay, you again you tell me that if I want to make my public issue successful, minimum subscription percentages are how much? So all of you know, I think it is 90% if I'm not wrong. Huh? Minimum percentages are 90%, right? 90%. But what if the company could not secure this 90%? Then what will happen? If company could not secure this 90%, then it has to refund the amount. So suppose let's say there's a company, it could get only 75%. Okay, what is the missing amount here? 15% are still yet to be recovered. So in order to show that they secured 90%, for this 15%, they will enter the fake journal entries in the books of accounts. Fake journal entries. Now, how you will go with the fake journal entries? Simple. You will simply write like this, that cash or bank account debit to shareholders account, and then shareholders account debit to share capital account. This 15%. How much time you take just to arrange this adjustment in the books of accounts? By passing this journal entry, can I say that you can show your subscription as minimum 90%? Hello? दिखा सकते हो नहीं दिखा सकते बताओ? Come on. Can I say it's fictitious? There are no any genuine shareholders who are willing to buy your shares. Everything is totally fictitious here. Isn't it a fraud? Isn't it a fraud? How can you show this 15% which is not received by you as received by giving the wrong name or false names of the shareholders? In order to prevent such malpractices, the government of India has come up with Section 38. And Section 38 clearly says here that if anyone is found getting the shares under fictitious name or allotting the shares in the fictitious name, understand it is applicable to both the people who are getting the shares as well as persons, that means the company which is allotting the shares. Then there will be a punishment under section 447. There will be a punishment under section 447, and all those people who received the shares in the fictitious name, their shares will be confiscated by the government of India. The money will not be given back, and company intentionally if issues the shares in fictitious name, then it will be considered as a fraud. And look at this, what is written over here. It is written that shall be punishable with the imprisonment for a term which shall not be less than 6 months, but which may extend to 10 years. So can I say it is the same? It is the same provision as was mentioned under section 447. Not only to that, but the fine will be there, which will be amount involved in the fraud and which may extend to the 3 times of the amount involved in the fraud. So isn't it section 447? Hello? क्या section 447 नहीं है here? It is of course section 447. 447. All right. Section 30, announcement regarding proposed issue of capital. So that is about allotment. I do not want to take it right now. It is about the pro rata. Sometimes we don't give the shares to everyone, but we give the shares to only and only the pro rata basis. Pro rata basis. All right. So that's all, students. That is done over here. And these all are the previous attempt question papers with the attempt name. Look, just ignore the marks and all that, but read all these questions and make this exercise. And tell me, are you people comfortable with this or not? Read the first question. Question number 1, and tell me, are you comfortable with this or not? All right, second question. When may a public company commence business after issuing prospectus to subscribe its shares? So understand when you can start your business, that means when you can start utilizing the funds. So simple, when you get a minimum subscription, when you get the application money, when you, no, not only after obtaining 90%, when you allot the shares, because if you have received the money, but if you have not allotted the shares yet to the people, can you use the money? Can you use the money? Answer will be no, you can't. All right. After the third question, please. This was the November 15 question. Explain the concept of deemed prospectus under the Companies Act 2013. Are you fine with this? Guys, these questions are not available in your material. I will give you separately, or you please keep on taking the snapshots of this. Okay. So these are the 3 questions here. After then, चलो मैं अलग से दे दूंगा. Remind me, give me the questions. I will give. Again, it is the deemed prospectus concept. This question, RTP May 16 का question है. Read this. Read this. And tell me, can you solve this question or not? These are all the ICI's question. Come on, read it. Read it. चलो, and tell me, are you comfortable with this or not? Sure, Shruti, I will do that, but not now, because in this material I need to change certain points, and then I will share. Okay, I need to make certain modifications, but don't worry. Within 2 or 3 days, you will definitely going to get this. All right. So, tell me guys, are you comfortable with this question? RTP message string question. All right. November 12 for the 8 marks. This question was available. State the liability of an expert in case of misrepresentation in the prospectus. Tell me, students, what are the liability? What are the liability? Only 3 liabilities are there. Section 34 talks about civil liability. Section 35 talks about bolo criminal liability, and section 36 talks about fraud. And after that, they have asked the question that when an expert will not be liable for his untrue statements made in the prospectus. So guys, you tell me what we need to write here. What we need to write here? Can I say we need to write the defenses of civil as well as criminal? ठीक है? तो ये यहाँ पे question थी. Next point is who is an expert, and when an expert is not liable for a misstatement in the prospectus of a public. Can I say it is the repetition of the same question? November 2002 for the 5 marks. When is an expert not liable for the untrue statements in the prospectus? November 6 for the 5 marks. Only defenses are asked. Next question is who is an expert? When is an expert not liable for the misstatement in the prospectus of a public company? What is the extent of liability? So again, guys, it is the repetition of the same question. RTP May 13 का question है ये. GDR, guys, GDR का question I will tell you in membership chapter, not right now. After the read this, create the provisions relating to information memorandum. It is not as per 1956. I'm sorry, it is actually 2013. It is very old. May 13 for the 8 marks it was. So information memorandum is getting used only at the 2 places: shelf prospectus as well as second क्या ना? It can get used at the 2 different places. One is at the shelf prospectus, second is at red herring prospectus. Did I tell you that at both the places you need to provide the changes, and where you are providing the changes, whenever you are providing the changes, it will apply. Got it? After then, again guys, if you look at this, what are the provisions relating to information memorandum? All right. Minimum subscription concept I will not teach right now because that I will take separately in the allotment chapter. So ignore these questions. Minimum subscription. This question, May 13 for the 4 marks. Read it. Wiser Limited issued a prospectus inviting the public for subscription of its equity shares, stating in that the company possesses good financial health and paying dividends to its equity shareholders consistently and regularly at the rate of 20% over the last 5 years. Have we ever done dividend case in our classroom regarding material misstatement? किया है case? आगे बढ़ते. The fact was, company was running in losses since last 3 years, and it was paying the dividends to its shareholders out of accumulated profits. Mr. Amit read the prospectus and bought 500 shares from the company. Discovering the misstatement made by the company in the prospectus, he wants to resign the contract and wants to claim the damages from the company. Referring to this provision, explain whether can he succeed or not. So guys, here one point मैंने जो आपको नहीं बताया वो मुझे आपको बताना पड़ेगा. Wait. One question I did not tell here, and that is also important for your exam. And what is that? Let me tell you. Right down here, the question is who can claim the remedy for misstatement? Who can claim the remedy for misstatement? For example, Mahima, she was allotted the shares from the company in IPO. And if she finds material misstatement, can she claim the remedy? Second point, Mahima sold to Shruti. Mahima sold the shares to Shruti. And now Shruti suffered the loss. She suffered the loss. Can she claim the compensation on the basis of material misstatement? Third, Ishika, who read the prospect, okay, Ishika, who subscribed in IPO but is not aware about the contents of prospectus. Can she claim the remedy under fraud? Means can she file the complaint on the director and can she send them to jail? That is the question. Fourth question, very important. Shruti, who relies on prospectus and subscribe to IPO of the company on the profit of 5 lakhs, wants to file the complaint under misstatement. Look, all the four examples what I am providing over here, prospectus contains misstatements, material misstatement. A lot of wrongful information is provided in the prospectus. And here the question is, can all these four people, Mahima, Shruti, Ishika, okay, fourth one is not Shruti, but let me take here Mr. Prem. Can all these four people go under section 447 and can hold the directors liable on that? Guys, are all the four questions clear? Okay, you copy this all the four questions, and one of the facts what I want to present here is in all these four cases, prospectus contains what? Material misstatement. Let me solve the first question. Law says here, in order to claim the remedy under material misstatement, following conditions must be fulfilled. Following conditions must be fulfilled. I want all of you to just note it down, all the four conditions. First of all, the complainant must be allotee. Allotee, do you understand? That means he should be the first one with whom the company has made the contract. So you just come to the first and second point. Mahima subscribed in IPO and company gave the shares to Mahima. Later on, Mahima sold the same shares to Shruti. So whether in the second example, Shruti had any direct contract with company? So can Shruti be considered as allotee? Can Shruti be considered as allotee? No. Shruti is buying the shares from the secondary market, not from the primary market. Do you understand? Huh? And that is why if you are just relying on the secondary market statements, the market fluctuation, you tell me in my second example, Shruti bought the shares by relying on the prospectus or by relying on the market fluctuations? Answer the question. Shruti, if I talk about Shruti, whether Shruti has bought the shares by considering what? Shruti has bought the shares by considering what? So answer here is she bought it by considering what? Only and only market fluctuations. And that is why in this question, Mahima is only the person who can file the complaint. Shruti cannot. So you should be allotted. That means you should have bought it from the primary market. Second condition is the allottee must have relied on the statement materially misstated. This is very interesting. What do you mean by this? Look at the fourth question. Prem, just a second. Right? Third question. Ishika who subscribed in IPO, but she is not aware about the contents of prospectus. So she is allottee, but she doesn't know what is written in the prospectus. Just one broker said that this is a good company for the investment, please invest it, and that is why Ishika invested. So can Ishika claim a remedy for the misstatement? Again the answer will be no, because understand, law clearly says, okay, you understand, when I use the word material misstatement, can I say this statement material misstatement, meaning of materiality can be different person to person. Something what is significant for you may not be significant for me. Do you agree with this statement? Hello? Something what is material for me may not be material for you. Possible? Something what is important for you may not be important for me. So whether anything is material or not, that depends upon the personal perspective. Personal perspective. So something what I have not considered at all, it cannot be material for me. So what law says in the second condition, that allottee must have relied on the statement which is materially misstated. The example is the position of the directors doesn't matter for me. Whether they are culprit, whether they are convict, whether they are criminal, doesn't matter. I invested in the company by looking at the good performance in the history. Some directors are criminals, but I don't care. I don't care. Profit and all this stuff was properly mentioned. Okay, it was properly mentioned. Properly mentioned. So I consider profit and the financial parameters, and I invested in the company. Actually, the directors were criminal in nature, but it was not disclosed in prospectus. Obviously, it is a misstatement. But later on, students, if I suffer the loss, can I claim that directors are criminal in nature and that fact was not disclosed in the prospectus, and that is why I want to claim my loss? Understand, at the time of investment, I did not rely on the director statement, but I relied on the profit statement. So the director statement which was misstated, does it material for me? Come on, is it material for me? Is it material for me? Hello? Is it material for me? Is it material for me? I did not focus at the time of investing on directors. So my base for investment was only profit and the performance. Directors were not in my radar at all. So whether it is wrong, whether it is right, it doesn't affect me. So this statement is very important, which is the defense for the company. Allottee must have relied on the statement which is material misstatement at the time of investment. If my base of investment was not that misstatement, then I cannot claim the remedy. Hey, are you clear with the second example or second condition? Come on. Are you clear with the second example? All right. Third, it says that allottee must have suffered the losses. Must have suffered the losses by relying on this misstatement, by relying on these misstatements. So look at the fourth question. Prem, who relies on the prospectus and subscribes to IPO, earn the profit of 5 lakhs, and later on he wants to file the complaint stating that it is material misstatement. So can Mr. Prem get the remedy over here? Understand, you can file the complaint of fraud if it is loss to you. When there was no loss at all, you are earning the profit, then I'm sorry, you do not have right to file the complaint for the section 447. And the next point over here is, it says that complaint must have been raised within reasonable time. Can you file the complaint after 10 years of investment? Suddenly you realize, oh my god, at that point of time there was a problem, now I want to get it. No, you cannot. So guys, these four are the conditions if you want to get the remedy under material mistreatment. I want all of you to just note it down, please. Done, guys. I hope everyone has done. Very good. All right. So obviously, if he relied on that part, he can definitely claim the damages over here. Okay, guys. Let's go to the next question. It says that P Limited issued and published its prospectus to invite the investors to pursue for its shares. The said prospectus contained a false statement. Mr. X purchased some partly paid shares of the company in good faith from the stock exchange. Guys, this is saying that Mr. X purchased the shares from the stock exchange. Answer the question, does he have any remedy? Does he have any remedy? Does he have any remedy? He bought the shares but from the stock exchange, not as being the first allotee. So now if you have the clarity on this point, I think you can easily understand that in which direction this explanation is going on. So subsequently, the company was wound up and the name of Mr. X was included in the list of contributaries. Whether Mr. X is liable to pay the unpaid amount, can Mr. X sue the directors of the company to recover the damages? So Mr. X is liable to pay and Mr. X cannot file the suit for recovery. Got it? Hey guys, is this question clear? May 16 for the 4 marks? All right, I hope it is clear. Very good. After that, let's go to the next question here. Modern Furnitures Limited was willing to purchase Teakwood Estate in Chhattisgarh state. Its prospectus contained some important extracts from an expert report giving the number of teakwood trees and other relevant information in the estate in Chhattisgarh. The report was found inaccurate. Mr. X purchased the shares of Modern Furnitures Limited on the basis of the above statement in the prospectus. Will Mr. X have any remedy against the company? And yes, then what? So answer the question, guys. Can he claim the remedy if it was inaccurate? Can he claim that? Obviously, yes. It is a misstatement and he relied on that. So basically, in this question, we have to put all these 4 conditions what I'm presenting. Clear? All right. What is the law relating to criminal liability for the misstatement? Already we have done November 11th for the 4 marks. It was there. Correct. All right. Next question is about a company issued a prospectus. All the statements contained therein are literally true. It also stated that the company had paid dividends for a number of years, but did not disclose the fact that the dividends were not paid out of trading profits, but out of capital profits. I think the same question we have already done for the in the classroom, isn't it? Same question we have already done in the classroom. So again, I do not want to repeat it here. Fine. Next point it is trying to say is Peak Limited company issued and published its prospectus to invite the investors to purchase its shares. The said prospectus contained the false statement. Mr. X purchased some partly paid shares of the company in good faith on stock exchange from the stock exchange. I think this is the same question we have already done. May 2008 for the 5 marks. Did you observe that sometimes the ICAI is repeating the questions? Sometimes ICAI is repeating the question. Did you observe that? Hello? ICAI is repeating the questions. So solve the questions as many as possible to get the idea of what kind of patterns would be there in exam. All right. The next question is about with a view to issue shares to the general public, a prospectus containing some false information was issued by company. Mr. X received a copy of the prospectus from the company but did not apply for the allotment of shares. This is very interesting. He did not apply for the allotment of the shares. The allotment of the shares to the general public was completed by the company within the stipulated period. A few months later, Mr. X bought 2,000 shares through the stock exchange at a higher price. Now look, the moment when these facts are given in the question, you should have idea that the question is going in which direction. You tell me, can Mr. X here claim the remedy under the misstatement liability? Answer the question. Answer the question. Can he claim that? Can he claim that? Why only 2 or 3 students are replying? What others are doing? But if you are not interested, then let me know. I will arrange other faculty. ऐसा मत करो बेटा, अगर आप इधर हैं तो please keep on responding there. कोई और आके पढ़ाएगा, वैसे भी आपको पढ़ना ही है, ठीक है? Zombies की तरह बैठने से तो कुछ नहीं रहेगा. ये आपके बैच में हर बार क्यों हर फैकल्टी को ये ऐसा होता है? Why are you not responding? ये पता नहीं चलता. All right. There are a lot of questions. एक काम करते बाकी के questions खुद कर लेना. मैं अभी क्लास में नहीं करवा रहा हूँ, ठीक है? क्लास में नहीं करवा रहा हूँ. By the way, I'm going to share those questions to you. क्लास में करना है या खुद करवा दो बताओ? Do you want me to solve these questions in the classroom or will you do on your own? We will do it, sir. Okay, no problem. Do it. Fine. So that is the end of the prospectus chapter. I hope you have learned. I hope you have enjoyed this. Now just take a small break of 10 minutes. Let's freshen up and then I will continue. Okay? Good luck. All right, welcome back after the small break. So, are we good to go? Can you start now? Yesterday, I told you to just inquire from the other students that why they are not joining. So, anyone tried to ask them that what is the main problem? I want to know for the sake of feedback. दिक्कत कहाँ है? Anyone just tried to ask to them that what is the problem and why they are not joining? Hmm? There was an ANSEM exam today. Today, how can be the ANSEM exam? ANSEM exam got postponed now, I guess. The new schedule has arrived. So that is fine, but okay, how are you giving this online or only this exam because it was online? All right, but how can they keep on Sunday? That I could not understand. All right, may I know how many of the students are preparing for this your subject called Commerce and Indian Society? Approximately out of the total available in our class. Only second years, so about four of us are giving the exams. ठीक है. All right. Okay, let me know if it was held at 11 January. It is already completed, I guess. Huh? But today on Sunday, how can they keep on Sunday? All right. Fine, no problem. I think we should continue. We should. Other days, others had CA classes, so they just kept it when almost everyone was free. Did you inform this to Sunil sir or Kritika ma'am or Bhavesh sir about this? Because if today any exam is going on, then officially, is it on Sunday? Are you sure it is on Sunday? Just a second, just a second. Let me just contact with him. Okay, just a second. Okay, students, I just spoke with Sunil sir about this matter, and he's also concerned about this. The thing is, you people are not reacting. That is the major issue. And I think this is not for the first time where the faculty is telling you. It happened for many times, but don't worry. This will not stop me from performing my duty. No matter how much number is there, we will go. Because this class is for those students who are really willing to learn, who want to perform. Look, if students are expecting us to give some entertainment and all that stuff, then I'm extremely sorry. We are not here for dancing and singing and all of this stuff, right? We are here for teaching about those points which would come in your exam. And you're expecting us to have some fun and some all that. That's not going to happen. Yeah, occasionally it's fine. Sometimes we do, but all the time this class cannot get screwed up because of that. All right, so we will continue. I consider this the students who are present in my seriously now. I want to ask you guys: are you people really comfortable with what I'm teaching here? Come on, I want to know from your side, all of you, whosoever is here. Are you really understanding? Are you really getting what I'm putting? Because I never expected that just at the third or the fourth session, I need to give this much lecture to you to be serious. You were serious. And suddenly, I can understand it is COVID-19. But look, nothing is permanent, not even COVID, not even pandemic. So the life is not going to be stopped. So keep on moving. Do not think that the way the 12th standard people have passed without giving exam, same way you can build up the career. Oh my God, how many times I should repeat this? God knows. Okay, students, let's begin with the new chapter now. And the new chapter's name over here is the share capital. All right, share capital, share capital. And in the share capital chapter, we have point number one, and that is the basic concepts of share capital. Basic concepts of share capital. So as usual, before I start teaching that, okay, just one another announcement to all of you. Just a second. Yeah, share capital. Let me have fine. Where is the material? All right. Before I start the share capital, it is a lengthy chapter. I want to start some small one. Okay, let's begin with the small chapter here, and it is the membership. Membership charge. I will teach later on. Let's begin with membership. Membership in the company. All right. Membership in the company. Share capital I will take later on because very few students are there. Maybe if they are joining later on, I don't want to. Let's take one small chapter here. That is the membership of the company. Now, what are the topics you people are going to learn in this membership chapter? Please write it down here. First point, you please write down here the definition of member. Definition of member. Membership of company. Definition of member. After then you write down the next point, and that is the difference between member and shareholder. Difference between member and shareholder. After then write down modes of acquiring membership in the company. Modes of acquiring membership in the company. Acquiring membership in company. After then, this is very interesting and very important. Who can become member in the company? Who can become member in the company? Second, the point of GDR, what I did not teach there. Now I want to cover it here. Write down GDR holder and membership. GDR holder and membership. And another topic is cessation of membership. Cessation of membership. Rights of members. Rights of members. That's all. I want all of you to just note it down, the small chapter of membership, and then we will start discussion on that. Type the word down when it's done. Thank you. All right. So let's understand now, first of all, the basic explanation about the membership. And then the point here is, since our commerce study started, we people are believing that membership and shareholders, these two concepts. Sometimes we are using the word membership, sometimes we use the word shareholders, but technically, are these two terms same or different? What do you think about it? Technically, are these two terms same or different? They are totally different. Membership is different concept. Shareholder is a different concept. Now, what is the difference between these two? Let's understand this. If you read the most of the contents of the Companies Act, they're emphasizing on the members and not the shareholders. Look, I, I want to use the two different words, two different statements. You need to tell me which statement is correct and which one is not. Okay. Member is member because he is shareholder. This statement is correct, or shareholder is shareholder. Wait. Just a second. Just a second. Okay, screen is. Oh, I'm sorry. Okay, जाने दो उसको अभी तक. So one statement I'm using, you have to tell me it is correct or not. If I talk about the private limited company and public company, minimum number of shareholders in the private are 2 and in public it is 7. Is it true or correct? Answer the question. Is it true or false? Okay, let me tell you, this is totally false. Why it is totally false? If you read the section number 3, what is written over here, it is written that minimum number of members should be considered and not the shareholders. So minimum number of members in private limited should be 2, maximum 200. Minimum number of members in the public limited are 7 and maximum unlimited. So understand the word shareholders are not written. But sometimes we people believe that members and shareholders, these two are the same thing. I want to stop you. These two are not same thing. They are totally different, altogether different. The concept of membership is different. The concept of shareholdership is different. Now, where the difference is lying? Where the difference is lying now? कहाँ पे difference है? If you read the basic meaning, I will read the definition later on. Member is the person generally whose name is appearing in the register of membership, whereas the shareholder is the person whose name is who is who is holding the shares who is holding the shares in his name. So understand these two concepts are totally different. Member is the person whose name is appearing in the membership, and shareholder is the person who is holding the shares. For example, there is a person called, let's say, Mr. Ram, okay, who is holding the 5 crore rupees shares in the company. and suddenly he died due to cancer. Now his son, Mr. Rahim, will be considered as member or shareholder of the company. Is he a member or shareholder? Explain with your knowledge of Companies Act. Is he considered as a shareholder or he is considered as member of the company? So understand, Rahim will be considered only shareholders, only shareholders, only shareholder. He will not be considered as a member. Why? Understand, Mr. Ram, when he was a shareholder of the company, he was a member as well as shareholder in the company. He was holding the share as well as his name was appearing in the register of membership. But after demise of Mr. Ram, automatically all the shares got transmitted in the name of Rahim without any formal procedure, just as a will of Ram. Mr. Rahim is his legal heir, and that's why all the 5 crores rupees shares got transmitted in the name of Rahim. So Rahim is shareholder. You tell me, still his name is there in the register of membership? Answer will be no. His name is still not there in the register of membership. I'm talking about Rahim's name, Mahima. Don't make mistake. After death, only he's holding the share. His name is not there. If Mr. Rahim wants his name entered into register of membership, he needs to perform certain formality. And what is that formality? Simple. He needs to go, he needs to go to the ROC along with the death certificate and the share certificates of his father. He needs to convince the company that his father is no more and he is the real legal heir or successor of his father's property. So strike off the name of my father and let me in as new member in the company. So on the basis of all the records and all the what I can say shares people have provided, company will strike off the name of Mr. Ram and will enter the name of Rahim as the new member in place of Mr. Ram. And this is how Rahim can get the membership. This is how Mr. Rahim can get the membership. Got it? This is how Mr. Rahim can get the membership. So understand shareholder concept and membership concept is altogether different. Another concept I want to tell you about it is the person who is holding the share warrant. He cannot be considered as member anymore. He cannot be considered as member anymore. Why? Okay, if you want to get this answer, share warrant cannot be considered as member, but why? Write down this question. That why share warrant holder cannot be considered as a member. Write down. Why share warrant holder cannot be considered as member of the company. Why share warrant holder cannot be considered as member of the company. Yes, Mahima knows about that. Very good. Now let me tell you why it is like so. So there are two concepts. The first concept over here is the share certificate. And second is the share warrant. Understand. There are two different documents which are practically available in the company's management. Share certificate versus share warrant. Now, if you want to understand about this share certificate and share warrant concept, first of all, you have to know about the transfer of the share versus transmission of the share. Okay. So do you know what is the difference between transfer and the transmission? Okay, you tell me the example what I'm presenting over here, is it a transfer or not? Let's say here Miss Ishika, she wants to sell her 5 crore rupees shares to Mr. Prem. Ishika wants to transfer her shares to Prem. What did she do is she obtained 5 crores from Prem and handed over share certificates worth of rupees 5 crores to Prem. Is it called a transfer? Just if you're handing over the share certificate to somebody else by taking the money, can Mr. Prem enjoy the ownership of shares or not? Answer the question. What you have done simply, you have taken the money and in exchange of that you have given the share certificates. So is it called a transfer? Can Mr. Prem enjoy the title on the shares or not? Can Mr. Prem enjoy the title on the shares or not? So answer to this question is no, not at all. Mr. Prem cannot enjoy this. Because you tell me you have just handed over the shares certificates to Prem. But the point is whose name is reflecting in the register of membership yet? Ishika or Prem? Still Ishika's name you will find that it will be reflected in the register of membership. So आप चाहे कितना भी try कर लो, all the benefits will be enjoyed by Ishika only. Dividend will be given to Ishika. Notices will be given to Ishika. Bonus shares will be given to Ishika. Right shares are issued, given to Ishika. Any benefit arises, it will be given to Ishika, not to Prem. Prem को कुछ नहीं दिया जाएगा, सब कुछ इशिका को दिया जाएगा. So isn't it unfair? Isn't it unfair? The point here is how then Mr. Prem can enjoy the membership and shareholding rights. Because in the records of the company, still Miss Ishika is the shareholder, not Mr. Prem. So mere transferring the share certificates is not sufficient. So what is the process then? What is the process of transfer then? What is the process of transfer then? Okay, anyone has any idea? I think you are learning this law since your, I think, CA foundation. So do you have any idea how the transfer takes place between two parties? So look, there are two different mechanisms. The first is the shares can be categorized into these two parts. First, they are in physical form. And second, the shares are in electronic form. Okay, when I talk about the shares are in electronic form, that means I'm talking about the shares are in dematerialized form. It is in dematerialized form. Have you heard about that demat account and the share market value and all that? Huh? Right? They are in the demat account form. So over here, there is no any formality, simple on the computer click basis. Computer click basis, you can transfer your shares from you to somebody else. Click it and shares are sold. But if it is in physical form, guys, then share transfer is very much difficult. Why? Because it is in paper format and name on the paper needs to be changed. And that is why there's a formality. What formality you need to focus here? Let's understand this now. First of all, you need to download the transfer form. From ROC website. From ROC website. Download the transfer form. From which website? ROC website. It will be signed by both the parties. That means transferor as well as transferee. It will be stamped. Stamp, you understand, right? It will be stamped. Stamped means you need to pay some stamp duty to the state government. तो stamp भी pay करना है, signature भी दोनों का होना चाहिए. All right. And then students, these documents like transfer form. So transfer form is also known as transfer deed as well as instrument of transfer. That you need to download. You need to. It needs to get signed by both the parties. It needs to be stamped, and then it will be deposited to company along with share certificate. It will be deposited to the company along with share certificates. Now, did you understand? There is signature of both the parties. That means transferor wants to transfer the shares, transferee wants to take the shares. So there is a consent of both the parties. Now company will examine that application of the transfer, and if it finds everything appropriate, that there is nothing any fishy, there is nothing called fraudulent, can student, okay, let me write like this, if company is satisfied and there is nothing inconsistent, there is nothing problematic in transfer, then company will strike off the name of transferor and insert the name of transferee in the register of membership, and then company will issue new share certificate to transfer. Company will issue new share certificate to transfer. Right? So have you people understood how the things are going on? And that thing. So mere handing over the share certificates to the transferee doesn't make him the new shareholder. This is the entire, this is the entire formality you need to follow. Download the transfer deed, get it signed by both the parties, stamp it, deposit it with the company along with the share certificates. Then company is, if it is satisfied, it will issue the new share certificates in the name of transferee, and simultaneously the new person's name will be entered into the register of membership. This is how he becomes shareholder as well as member in the company. But this would apply in the case of the physical form shares. Hey, type the word clear if you got till this. All right, this is how the things are going on. So this is the definition of transfer. Whatever I taught here, it is the definition of transfer. This is how the shares in physical form, paper format, are getting transferred. But another question here is, what is transmission then? So any smart student who can tell me about this? What is transmission here? Because sometimes in exam, there's a question that write down the difference between transfer and transmission. So how will you write about it? तो भाई ट्रांसफर क्या है, ट्रांसमिशन क्या है, आप कैसे लिखोगे उधर? Okay, so transmission, write down, there is no formality. There is no formality. That means no need to download any share transfer form. You don't need to get it signed by both the parties. Over here, the shares are getting transferred automatically. Write down, it is shares are transmitted automatically without any formality by operation of law. तो कानून की वजह से, due to operation of law, the shares are automatically get transferred. Now your question is, but sir, how? So you look at in the previous example, Rahim obtained the shares, but by following the transfer procedure, or it got transmitted automatically? Answer the question. In the above example, Rahim, what I discussed here, Rahim became the shareholders of those shares, but how did he become? So he became the shareholder of the company automatically by operation of law. Law says even if there is absence of deed, if there is no deed, even in the absence of deed, you can become the shareholder of the company, because after the death of father, only legal heirs can enjoy the things. So you know that very well, right? You know that very well. All right. So shares are transmitted automatically. There are two examples where transmission actually happens. Write down the example number one here. Example number one, transmission when on the death of person. Transmission of shares to legal heir on the death of the person. Second, during insolvency, shares of insolvent gets transferred to official receiver without any problem. So when there is insolvency, shares are automatically gets transferred in the name of official receiver automatically. Automatically it gets transferred. So you don't need to perform any transfer formality. So and during these two circumstances, even if you do not follow the above procedure, the person becomes shareholders. They become shareholders. So that is the fundamental difference between transfer and transmission. But if you remember, I was explaining about the share certificate and the share warrant. So you tell me, are you people clear till this? All of you? Very good. Now, here, the point is, just a second, just a second. Okay, again, I want to guys, all of you are clear till this, right? No problem. Now, difference between share certificate and share warrant. चलो उसके बारे में थोड़ा समझते हैं. Share warrant versus share certificate. So if you have share certificate, every time if you want to transfer, for example, here this is the chain. Mr. A wants to transfer to B. B wants to transfer to C. C further wants to transfer to D. D further wants to transfer to E. E further wants to transfer to F. Do you know what is the problem here? Every time you need to download the fresh transfer form, you need to get it signed by the people. That means the transferor and the transferee. You have to pay the stamp duty to the state government. So every time you need to pay the stamp duty to the state, isn't it? And the people are really not interested in the membership. You tell me, most of the people who are investing in the share market, for what reason? Can I say only for the profit? Only for the price fluctuation? Hello? उनको क्या चाहिए? Speculation. पैसा चाहिए. They are least bothered about voting rights. They are least bothered about what is happening in the management. They are least bothered about. So stamping is the main issue, and that is why what they are telling that they say that we do not want. Some people say that we do not want share certificates, rather we want the share warrants. Now share warrant means what? Share warrant is a bearer instrument, right? Off. It is bearer bearer instrument. What do you mean by bearer instrument? It means the person who is holding it. It means the person who is holding it can enjoy the shares, irrespective of the fact that who is transferring. Whosoever is holding will be considered as shareholder without transfer. Without transfer. Got it? And issuing the share warrant is possible. How it happens right now? How company can get the share warrant? The shareholder can get the share warrant. So first of all, share certificates are issued. After then, okay, what I'm explaining is write down the process to issue share warrant. Process to issue share warrant. So here, the first of all, the share certificates are issued. Second point, shareholder will surrender the share certificates to the company with request to convert it into share warrant. Okay. AOA of company. Hey guys, are you people getting what I'm trying to say? First of all, share certificates are issued to the shareholders. Anybody who wants to get a share warrant will apply to the company. Second, company cannot directly allow this until and unless it is provided in the articles of association. So AOA of company must contain the provision to issue share warrant. If these provisions are not there, then I'm extremely sorry, you cannot go ahead with that. So articles of association of company must contain the provision to issue the share warrant. Alright. Then company will issue share warrant in place of share certificates. Now the important point is, look, if I have 5 crore rupee shares, but I have share warrant instead of share certificate, and if I transfer that share warrant to Mahima and Mahima gives me 5 crores, can I say the transaction is completed, or I need to go to company for the confirmation? Answer the question. If I take my 5 crores, and I hand over share warrant, can Mahima become next another shareholder? Another shareholder. Answer will be, come on, my question to all of you. Answer will be absolutely yes. Now Mahima will become my next shareholder. But there is another problem, another limitation. What is that problem is, you should have a doubt, then what about the register of membership? Because right now still Mr. Chirag's name is reflecting there. What about the dividend? What about the bonus shares? A lot of questions are there. Because if you are transferring the shares without intimating the company, then what about all these privileges? So understand, just it is very much difficult to manage the membership when there is a share warrant. Do you agree with this? It is very much difficult to manage the membership when there is the share warrant, because share warrant is very much what I can say transferable just mere by delivery. It is bearer instrument. Is it possible for the company to keep the track record? To keep the track record? Is it possible for the company to keep the track record? Answer the question. Is it possible for the company to keep the track record? Who is the member right now? No. And that is why, guys, write down very important note for your exam. It says that in case of issue of share warrant, name of shareholder will be striked off from the register of membership. Will be striked off from the register of membership. So there is no member now. There is no member now. So what have I tried to prove here? Can I say this is the situation where the person is shareholder but not member? So in case if there's any question that is there any possibility where the person is not a shareholder, sorry, not a member but shareholder, answer is yes. Share warrant is such a situation where share warrant holder is just a shareholder but not a member of the company. Because for the company it is not possible to trace who is holding the share warrant, and that is why it doesn't make any sense to keep the name of the old person as the member of the company, because shares are enjoyed by other party but membership is in the name of other party. That is legally invalid. That is legally invalid, and that is why the moment when share warrant is issued, the name of that particular person will be striked off from the membership register. Striked off from the membership register. Any type the word clear if you understood all the issues of the share warrant. Hello? Come on, clear? Very good. One more doubt here it is about the membership chapter, that is particularly share warrant. And that doubt is what about share warrant holder? Under any circumstances can he become member? Can he become a member? Right now? Under any circumstances, this is the question here. Under any circumstances, is it possible to make share warrant holder as member of the company? Answer will be right out. Answer will be yes, it is possible. Yes, it is possible. So how it is possible? Let's learn about this. How it is possible? Let's learn about this. Point number one, convert back to share certificates. Convert back to share certificates. And this what is very important. If articles of association of company allows to make share warrant holder as the member of company, then he can be treated as member. So if AOA allows, if the company allows in the articles of association that share warrant holder should also be considered as a member of the company, then and only then he will be regarded as member, otherwise not. Otherwise not. So now, have you understood the concept that why did I write this particular statement over here? What was the statement here? If you look at this, it is that share warrant holder is not a member. Is not a member. But why? And then we understood it. this entire discussion, this entire detail. So a lot of concepts of the complete law we have understood. What is the transfer? What is transmission? What is share certificate? What is share warrant? Effect of share certificate, effect of share warrant, effect of share certificates in the share warrant on membership, register, and the articles. I hope all the fundas are clear in everyone's mind. Could you scroll down a little bit, please? I think I should zoom it out a little. You want to write this yellow color, right? Notes. Okay, scroll down. That's all. There's nothing below this. That's all. Type the word done, guys. Once it is noted, then I will go to the definition of member. Come on. Fine. So here, let's begin with the definition of membership now. All right. Just to hold it, student, I need to make one important call. Can I take your 2 minutes if you don't mind? Thank you. All right, are we good to go now? So let's understand the definition of membership. Okay, I hope this is visible to all of you though. 10.1 membership in a company, right? So look, definition of member, what is written over here? So first of all, the membership is actually explained under section 2, subsection 55 of the Companies Act 2013. And according to this definition, there are three different classifications, or I can say there are three different points to be considered. Look at this. Read it and try to understand this. Look what it says. According to section 2, subsection 55, members have these three classifications. What it says? First, it says that the subscribers to the memorandum of a company who shall be deemed to have agreed to become members of the company and on its registration shall be entered as members in its register of members. What this sentence is trying to say, you answer one question, that when company is incorporated, let's say today the company is incorporated, from the day one, will company have the register of membership, or it will be prepared later on when everything gets normalized, share capital, all the payments, everything gets normalized. So when the register of membership is available from the day one, or it takes some 5 days, 7 days, or some time to prepare it? Answer the question. I'm talking from the date of incorporation. So it is obviously the common sense that it takes some time. It doesn't happen quickly. The तुरंत नहीं होता. It takes some time. ये कुछ time लेता है. It takes some time. So unless the register of membership is prepared, is it possible to have the concept of membership? Because let's say it will take 7 days to prepare. So what about the 7 days? Whether till 7 days, company will remain without members? There can be shareholders, but will company remain there without members until the register of membership is prepared? Answer is no. What law says that until your register of membership is prepared, subscribers to the memorandum of company will be considered as members? Do you agree with that? Whosoever, 2, 7, whatever. So first point, it is the exception to this rule which states that whose name is appeared in the register of membership. No, subscribers to the memorandum will automatically be considered as members of the company till the register is prepared. So from the, look, there are two different debate. Argument number one is until the register is prepared, there are no members. Argument number two, no, members are available from the day one. So which argument is correct? So second number argument is correct. Why? Because all the subscribers are considered as All the subscribers are considered as members from the day one. They are members from the day one. Got it? Second point, this is what I have already explained. Every other person who agrees in writing to become a member of a company and whose name is entered into register of membership. So look, there are two important words. The first is agreeing in writing to become member. So can I make a member of my company without you giving me consent? Can I make you the member of my company without your consent? No, I need to take your consent first. Okay. All right. Are those this first 2 points are clear to all of you? Hello. That first of all, you need to agreeing in writing. Agreeing in writing means what? Look, understand when I issue the share forms, share application forms, and when you sign it, that means it is your consent that you want to become member in the company. Got it? You want to become member in the company. So when you give your consent and when your name is entered into register of members, you become member. So the first part of what we have learned, it is about the memorandum. Second is about by agreement plus register. And the third point, what is written here, that is a little bit tricky. I want to give you the chance, you read the third point and please let me know that have you understood anything what is written here. क्या आप कुछ भी समझ पाए third point में? What is written over here? Every person holding the shares of a company and whose name is entered as a beneficial owner in the records of a depository shall be deemed to be a member of the concerned company. So the third point, have you understood about it? Ishika says yes. Oh yes. Then can you explain what it is trying to say? Meenakshi says all shareholders are members. Nah, it's not like that. It is not like that. Look, two important words are written. That words needs to be interpreted. The first word, what is written over here, is the beneficial owner, and second is the depository. It would be miracle if you understood without having knowledge of these two words. I thought you would raise this question, but I think you students have a lot of knowledge. Do you know what is beneficial owner? You can type the word yes or no. मालूम है आपको ये है क्या? Be honest. Don't try to impress me. Okay? Don't try to impress me. इससे मैं impress नहीं होने वाला. Because third point depends upon the understanding of these 2 points. ठीक है? इन दोनों के ऊपर ये सारी चीजें डिपेंडेंट है. All right, let's understand what is beneficial owner and depository. Okay, today I want to give you one opportunity, and your salary will be somewhere around 10 lakhs rupees per month. Would you like to do the job? Your salary will be 10 lakhs rupees per month. क्या आपको ये job करनी है? Anyone? किसी को ये job करना है? हर महीने आपको 10 लाख रुपए का सैलरी मिलेगा. 10 lakhs rupees will be given to you as salary. Will you do this job? Okay, Meenakshi says yes. Okay, other. I was expecting some smart answers stating that, sir, what is the job first? Tell us. पैसा दिखाने के काम करने को तैयार, ऐसा नहीं. First of all, you should know what is the task. Task is, there is a company called Tata Motors in which there are more than 2.5x members and which are fluctuating every day. Every day, more members are getting added. Old are leaving because they sold all their shares. What you need to do is you need to just maintain. Every day's record manually in the register of membership. ये आपको करना है. Every day you will find more than 1 lakh transactions where the shareholders are changing. Because today I have the shares, if I sell to you, my name will be striped off, your name will be entered. So all this you need to maintain, and per month you will be given 10 lakhs rupees. Will you do this? Will you do this now? Are you interested in doing this job? Now I think I'm expecting some negativity from your side. नहीं sir, अब नहीं करना है. अब नहीं करेंगे. But this is the reality. If you talk about any listed company whose shares are listed in the stock market, don't you see or don't you think that every day lakhs of people are buying the shares and lakhs of people are selling the shares of the same company? And some companies are always in the hot favorite in the market. Shares like you see Tata, Reliance. There are a lot of companies which are trading in there. They're always hot favorite. Lakhs of transactions are happening. So is it possible to maintain the register of membership? Answer the question. Members are changing. Members are changing every second. So would you like to do such job? All right. Is there any practical solution? Yes, there is a practical solution. Let's understand what is the solution is. So in order to understand the third point, हमें समझना पड़ेगा that how the stock market is operating. How the stock market is operating. ठीक है? So first of all, there are a lot of stock exchanges called Bombay Stock Exchange, National Stock Exchange, Kolkata Stock Exchange, Ahmedabad Stock Exchange, Bangalore Stock Exchange, Chennai Stock Exchange. I can say more than 24 stock exchanges are right now running in across country, but only two are famous. The first is Bombay Stock Exchange and National Stock Exchange. These two are famous. Remaining all are there, but not that much famous. Remaining are there, but not that much famous. तो उतने ज्यादा famous नहीं है. Are you getting the point? Hmm? Now, students, please confirm. Are you here? Oh, you need a break. Break चाहिए आपको? You need a break. Break तो थोड़ा break चाहिए. Break चाहिए. Do you need a break? What a public. They are not writing yes. They are not writing no. My God, how to? We will take 5 minutes break. हाँ तो बोलो ना कि you need a break. Okay, I got a private message. Fine, no problem. Take a break. Small break of 5 minutes. Then I will tell you this third point. ठीक है? Third point में आगे जाएंगे. Take a break. Class will resume exactly at 4:05. ठीक है? All right, students, so we can start now. I hope you are here and you have enjoyed your break. We can go with that, right? All right. So if you want to understand this third point, that every person holding the shares of a company and whose name is entered as a beneficial owner, if you want to understand these two words, beneficial owner and the depository, you have to learn about the entire stock market. That's what I was discussing. So generally in India, there are a lot of stock exchanges, but Bombay Stock Exchange and the National Stock Exchange, these two are very much famous. These two are very much famous. How they're operating? So everything is online. You know, today all the tradings are happening online through dematerialized format. And this dematerialized format is known as the demat form. Demat account you must have heard about, isn't it? Demat is the short form of this word called dematerialized. Now, all these stock exchanges actually are using one powerful software, which is managed by these two companies, NSDL and CDSL. Because if you want to trade this much online, don't you think that there must have one powerful software, one powerful information system? Should it be there or not? Should it be there or not? Hello? Answer the question. Should it be there or not? It is there. Everything is happening by using this powerful software. This powerful software. Now, how the things are happening, you understand how the things are happening. How the things are happening. So, NSDL has this powerful software called depository. Depository. Who are the members here? So anyone who wants to use this powerful software, they need to be the part of this particular depository, which they need to buy this software. They need to take this software by taking the license from NSDL. So BSC applies to NSDL, NSE applies to NSDL, and they are getting the licenses to use this software within themselves. You won't believe, but a few days back, I just heard in the newspaper that Ahmedabad, certain officers in Ahmedabad, certain officers when raided, they found that certain people are using their private softwares. Looks like as real share market, stock market software. And they were inflating and controlling artificial pricing. Artificial pricing. Now you try to understand if you have the private software and you are speculating in the stock market price within your private software, can I say it is just one type of private stock market? Private stock market, illegal and without license. Illegal and without license. So right now there are a lot of corners of the country, the people have this private software. Private software. By using this private software, they are creating the illegal stock markets, which is not allowed. If legally you want to use this software, you need to take the license from NSDL and the CTS. So Bombay Stock Exchange, National Stock Exchange, CSE, ASE, they're trying to do this. If you do not want to use this NSDL software, then you should have your own foolproof software. But development of this foolproof software is very, very, very expensive in nature. It is very, very expensive. बहुत पैसा लगता है वो, आसान नहीं है. Okay, till this everyone is clear? Depository, BSC, NSC, all these people, hello? So they are using this software. Now, who are the members of BSC, ESC? Understand. In this BSC, ESC, NSC, companies registers their membership. So for example, Infosys, it is the part of BSE as well as NSE. So Infosys like companies, they register their shares to BSE, Bombay Stock Exchange, and they become member of BSE. Every year they need to pay fees, membership fees, to have their shares continued with Bombay Stock Exchange. Okay, apart from this, another authority is also there which is controlling all these transactions. That is there any fraud is happening in this software or not. And the name of that authority is the SEBI. Have you heard about the SEBI? SEBI also observes that everything is happening according to the rules, regulation, and law or not. So Bombay, what I guess, thousands and thousands of the companies are getting registered under Bombay Stock Exchange, and their shares are getting traded under this software. Under this software. Now look at the ingredients. Software is there, stock exchanges are there, even companies' shares are also listed in that software. But the biggest problem is now how the trading will start. Because if there are no sellers, if there are no buyers, then how you can start, how you can start the selling and buying. And that is why, guys, BSE invites certain brokers, look at the entire explanation. Bombay Stock Exchange obtained the license from NSDL. Now Bombay Stock Exchange will further distribute this license to brokers. Some big and large brokers you must have heard about, like have you heard about Sher Khan? Sher Khan, Sher Khan के बारे में सुना होगा आपने? हाँ? You must have heard about Infoline. You must have heard about. There are a lot of brokers are available in the market who are taking the license from Bombay Stock Exchange. And these are the trading licenses. Are you getting my point? These are the trading licenses. They can literally buy the shares, they can literally sell the shares. Now, Sher Khan has a lot of other sub-branches. And in these sub-branches, there are a lot of customers. And when customers join Sher Khan like company, अभी वो और भी मार्केट में चल रहा है, जीरोधा करके एक वे है, Zerodha. Have you heard about Zerodha? And a lot of other companies are there. So these companies are inviting their customers that please become the participants in us. And once you pay certain fees to us, we will allow you to enjoy this software by opening your own small account and giving some confirm. If you pay us some fees, we will open your account and we will give you certain controls where you can buy the shares, where you can keep your money, where you can sell the shares. And this account is known as the demat account. You guys, are you people understanding how the whole syndicate is related with each other? How one large software is segmented into small demat accounts. Small demat accounts. Students, are you getting what I'm trying to say? Hello? Till this everyone is clear? I hope till this everyone is clear, right? All right. So look at the entire hierarchy. If you understand here, at the end there are customers like you and me. Above there, branches of broker. Above there's a broker like Sher Khan. Above there is Bombay Stock Exchange, and above Bombay Stock Exchange there is NSDL. And within the Bombay Stock Exchange there are shares and securities. The entire hierarchy is clear in everyone's mind. Until you have the knowledge of this entire hierarchy, it will be very much difficult for understanding the third point. All right. Now, if you talk about the company, who are the real shareholders? So technically speaking, if you look at this, who are the real owners? So can I say these customers are the real owners of the shares? But company cannot keep the record of them because they are fluctuating very much in a single day, and keeping this much record would be very much difficult for the company. Are you understanding the practical difficulty? It is not easy for them to keep the record. And that is why here it is mentioned that register of membership in case of listed company, register of membership of company will contain the name of share Khan. That means the brokers. Answer the question, whose names will be reflected in the register of membership? Broker's name will be reflected because brokers are not changing very much. Let's say Sher Khan. If Sher Khan has crores of shares of the company, until all the shares are sold to other, his membership never gets terminated. Are you getting my point? Hello? Until the Sher Khan sells all the shares of Infosys Limited, his membership doesn't get terminated. And that happens very rarely, isn't it? And that is why what is very easy to manage? Managing the names of brokers or managing the names of customers. If you are a company, what is very much easy to maintain? Only one student is answering. What about others? I think other I give the break तो दूसरे लोग सो गए लगते हैं ठीक है Is it like lullaby huh Chirag sir is singing a lullaby and अरे किधर हो सब लोग because if I check the chat box I can see only Sai Mama no one else is replying oh my god क्या are you there अरे भाई थोड़ा रिस्पॉन्ड करो दैट इज ओनली व्हाट आई एम एक्सपेक्टिंग फ्रॉम यू ठीक है इतना मान जाओ भाई इतना मान जाओ ठीक है you people are expecting a lot of respect I guess today नहीं सर और जरा थोड़ा और जोर से कहो all right so according to the law the register of members of the company will contain the name of these brokers but actually the broker is not a proper word do you know what is the proper word here hmm? The proper word is not a broker. The proper word here is write down. They are actually considered as depository participants. Can I say they are paying the license fees to the stock exchanges and on the basis of those licenses, they are participating in depository. Depository means that entire software, isn't it? They are participating in the depository and they are going for the trading. They are buying, they are selling the security. Getting the point? Okay. All right. So these are known as depository participants. Now you understand the company's register whose name is reflected. So DP's name is reflected. But if I talk about the DP's software, whose name is there? Customer's name is there. Are you able to understand this thing? Are you able to understand this? All right. Now answer this question. Even if the company's register of membership contains the name of depository participants, but ultimately, who are the owners of shares? Who deserves to enjoy the membership rights? Depository participants deserves to enjoy the membership right, or real customers deserves to enjoy membership right? Who are the people deserves to enjoy the membership rights? So answer to that question is real customers. So even if the name of depository participants is mentioned in the company's register, but real beneficial owners are the customers. Real beneficiaries are the customers. Are you getting my point? Real owners are customers. And third point says that even if depository participants' name is mentioned in the company's register of membership, but they are not members, the real beneficiaries, which is considered over here as the beneficial owner, those people are considered as real members according to the third point. So if you look at the third point over here, now you people are able to understand, I guess. It says that every person who's holding the shares of a company as being a customer and whose name is not there in the company's register, because that is not possible, whose name is entered as a beneficial owner in the records of a depository participant, he shall be deemed to be a member of the company. So again, this is the exception to the register of membership. Now, have you understood just one particular section called the section 2 subsection 55? Answer the question. Have you understood section 2 subsection 55? Section 2 subsection 55 here. All right, so that is about the entire explanation of section 2 subsection 55. Now 5, now you should have certain doubt, the doubt like but sir, what about the dividend? Because name is in register of membership contains the name of depository participants and doesn't contain the name of members. Then what about the dividend? How the general meeting notices will be issued? How dividend will be issued? So simple. Company will ask Sher Khan that give me the list of your customers on so and so date holding my shares. Possible or not? Answer the question. Possible or not? Company will simply ask depository participants that please produce the list of the members, beneficial owners as of this day. And on the basis of the information, you see, in the records of depository participants, it doesn't maintain anything manually. Everything is automatic because of this wonderful software. So everything is accurate. Everything is accurate. Nothing is fishy. Nothing is manipulated. So simply, depository participant will hand over that list of beneficial owner to the company, and on that basis company will issue the dividend, company will issue the notice, company will issue the bonus share, company will issue the right shares, etc, etc, etc. So never have this misconception having that if depository participant is there, then real members will not on the dividend. That is the misconception. It's not going to happen in that way. Guys, I want to give you the 2 minutes. During these 2 minutes, please refer this definition and try to remember that. Try to remember. Thank you. Please do that. I hope it is done. Then we can go to the next question. So we have learned just about the definition of membership. Now, difference between member and shareholder. I'm just going to present this material with you. My request is please read the difference between these two, member and the shareholder, and find yourself comfortable with this. So the first one is the term member is defined under section 2, subsection 55 here. But the term shareholder has not been defined under the Companies Act 2013. Second, the term member generally means a person whose name is entered in the register of members. The term shareholder means a person who holds just the shares of the company. Every company shall have minimum members number as members, but who can have the shareholders? You tell me the company which is company without share capital, is it possible for that company to have the shareholders? Is it possible for those companies to have the shareholders? No. So only a company having share capital can have the shareholders. Signatory to members, a person who signs the memorandum is deemed to be a member. So you tell me this point is talking about, can I say it is the point number 1 of section 2 subsection 55? Section 2 subsection 55, because entire definition has what I can say this is 3 parts, and this talks about part number 1. A person who signs the memorandum becomes a shareholder only when the shares are actually allotted to him. So until the shares are given, you do not become shareholder. So it is possible that even without a shares, you can become member. A transferor of a shares continues to be a member until his name is removed from the register of members. So do you remember that example that after death of father is still member until his name is striked off and his legal heir's name is validly taken in that. So where a person transfers his shares, he immediately ceases to be a shareholder, even though his name continues to appear in the register of members. So my request is to all of you take the snapshot of this entire difference, because many times in exam it was there. Do it and type the word done. Then we will go to the next question. Very good, very fast. Then let's go to the next question here. Next question talks about the modes of acquiring membership in a company. So some students are taking this as a very difficult question. Oh my God, what kind of question it is? In short, I want to tell you how to become member in the company. You tell me, according to the law, anyone to whom the share is allotted within reasonable time, his name must be entered into register of membership, except share warrant. Is this statement true? Is this statement true? Anyone who buys the shares, who gets the shares, later or sooner, his name must be reflected in the register of membership, except share warrant. This is true. All right, write down here. Note for exam. Note for exam. All persons to whom the shares are allotted or got transferred will be entered in the register of membership as members within reasonable time. Within reasonable time. Within reasonable time. So all the persons to whom the shares are allotted or got transferred will be entered in the room, in the sense here, you take it as a register of membership, huh? As members within what time? Reasonable time. So can I say later or sooner? Okay, there is exception. What is the exception? Except share warrant holder. Except share warrant holder. So can I say all the shareholders except share warrant holder will become members later or sooner? Hmm? So all shareholders later or sooner will become members of the company. Members of the company. Because right now they are holding the shares within 30 days, within 15 days, when their name get entered into a register of membership, they will become member of the company. Okay, so these two are not actually the different process. According to me, these two are interrelated process. These two are actually closely related process. दोनों एक साथ related हैं, related है. Why? So you see, if I ask you what are the ways to become member in the company, so can you tell me all those ways which are available to become shareholder of the company? Hello? When I ask you that what are the ways to become, what are the ways to become member in the company? So can I say that all those ways where you can become shareholder in the company, the same ways are available to become member in the company up to certain extent? Hi now? I'm asking to the whole class, not only to one class. All right. Thank you. So look at this, guys, what are the modes available? So first mode over here is subscribers to the memorandum. If you are subscribing to the memorandum, even though you are not allotted the shares, you will be considered as member. Got it? So this is about the subscribing to the memorandum. Second is, if you are participating in the IPO by application and the shares are allotted to you. Shares are allotted to you. So once we apply and the shares are given to you, automatically you become member in the company. If you transfer the shares, transferee becomes member of the shares of the company. Transmission of shares. Did you understand what is the difference between transfer and the transmission? Hello? I think we did it in detail. Transmission applies only under two circumstances. As I told you, legal representative of a deceased member. Deceased would mean over here the person who died, and second is the official receiver. These two concepts already I have discussed at the beginning of the chapter, so I don't want to waste my time. This point is very interesting. It says about by acquiescence or estoppels. By acquiescence or estoppels. Yes, Mahima. During the transmission, suddenly he doesn't become member until he produces death certificate and share certificates to the company. He needs to present that, and then and only then he becomes. But that's I told you, later or sooner he become. Because later or sooner, if he wants to enjoy the dividend, if he wants to enjoy bonus, so he must have to get his father's name removed, and he has to get his name entered into the register of membership. Until that thing happens, he cannot enjoy the benefits. So later or sooner, he has to do that. But my point is already we have completed that part, so it doesn't make sense to repeat those points again. This part already we have covered up. Okay. Now the next point is about the acquiescence or estoppels. It is just like the estoppel by partners. Suppose here Miss Minakshi, she is not a member of my company. All right. Let's take in this way. Suppose Meenakshi, she is not a member in the company, but Mr. Milan introduced her. Who is Mr. Milan? He is a director in the company. Introduces Meenakshi as 25% shareholder and member in the company to Mukesh Ambani. Okay, you tell me. In front of Meenakshi, when Milan is introducing her as the shareholder of the company of 25%, actually she is not. But instead of raising the objection, she remained silent. She preferred to remain silent. My question is, if she remained silent over here, can I say she's a member by estoppel? Hello? She is member by estoppel. She is member by estoppel. To the whole class I'm asking, come on. Member by estoppel. And that is why here Meenakshi is considered as by acquiescence or estoppel. And later on, if any liability is incurred on that part, then Meenakshi is liable. Meenakshi is liable. So if you read what is written over here, look at this. A person is deemed to be a member of a company if he allows his name without sufficient cause to be in the register of members of the company. So if allows, understand actually Meenakshi doesn't deserve to be there, but she allows herself to be the member of company. She had a chance to raise the objection, but she remains silent on that, or holds himself or allows himself to be as a member of the company. In such a case, he is stopped from denying his membership. Then later on, Meenakshi cannot deny from the membership. He can, however, escape his liability by taking prompt action for having his name removed from the register of members on the permissible grounds. What this point is trying to say here. Now, suppose the company in which Mr. Milan is director, company's name is Mr. Milan Services Limited, and it is a guarantee company. Understand? It is a guarantee company. What is the specialty about guarantee company? Can I say at the time of winding up, all the members are liable to the extent of guarantee? See a foundation concept. Come on. To the whole class I'm asking, guys. Okay, at the time of winding up, each and every member requires to contribute to the extent of guarantee they have taken. So here, according to the memorandum, everyone needs to pay 25 lakhs. Now, Meenakshi did not resist herself from denying the fact that she is not a member at the time of introduction. And that's why Mr. Milan later on took her as the member and entered her name into the membership register. Now the company went to winding up. In the register of membership, even if Meenakshi knew about the fact that her name is appearing as a member, she did not take proper steps to remove it. Whether Meenakshi is liable for 25 lakhs, that's my question. Whether Meenakshi is liable for 25 lakhs. It is to the whole class, come on answer. Whether Meenakshi is liable for this 25 lakhs. The answer to this question is absolutely yes. Meenakshi is liable. So if you want to get yourself removed from the liability, what is written in the last sentence, you have to take the prompt action and please get your name removed from the register. Then and only then your name will be taken back, otherwise not. And this part already I have done as beneficiary in the records of depository participant. Depository participant. Depository participant. All right, is it clear to all of you? Hello? So with your permission, I want to know, should I start the new topic called who may become a member, or should I leave upon the next class? Come on. Tomorrow? Okay, good luck, students. Thank you very much for the day. Very soon I'm going to share these two material. Okay, do not worry. Thank you.